Welcome back. Remember Judge Galiatsatos of the Court of Quebec last month during a criminal trial proceeding? He invalidated a section of Bill 96. Remember that translation requirement now that's Bill 96 imposes on the justice system, saying that a decision rendered in English must be simultaneously available in French. And citing this situation and looking at how the criminal trial he was presiding over was going, he said, well, look, this will create additional delays. And the Jordan decision, the famous Supreme Court of Canada decision saying that criminal trials have to happen in a certain amount of time, and if not, that violates the defendant's constitutional rights to a speedy trial. Well, he used that and he invoked it without this argument being put forward by either the prosecution or the defense. Now, this, of course, is going to be challenged in the courts, but now a nonprofit group called Droit Collectif Quebec has filed an ethics complaint, a judicial ethics complaint, saying the judge went beyond the ethics rules. So this could be an ethical violation. So to help us understand what's going on here, happy to be joined by Guillaume Pelegrin. He is a partner at Fasken. He's a lawyer that specializes in administrative law questions like this one. Guillaume, thank you for jumping on this morning.
Yes, hi, David.
So, in terms of the context, did I present this the right way, or am I missing an element
you're not
here?
missing anything. And I think it's important to look at the broader context here because we need to break this into three pieces.
Mm-hmm.
So there is first the very core, very serious constitutional issue here, which is the right of every Canadian to be tried in the official language of his right, and the right of every Canadian to have to receive a judgment within a reasonable time. And you raised it, the Jordan case. But that's not it. Because in addition to the Jordan case, you have the right for the judgment to be rendered by the judge when he is in his office writing it into a reasonable delay. So what actually changed with that new law that came into force actually 1 week ago, 1st of June, but it was enacted 2 years ago, is that when a judge decides to render its judgment in English, a French copy must be immediately available. So you can imagine that there is a lack of resources, lack of translators, lack of everything. So it adds delays. And this is the issue that the Quebec court judge took issue with and addressed in his decision. Are those additional delays caused by translation go against those constitutional principles?
Now, Guillaume, I thought when he raised this issue, both parties said, "Well, I haven't raised this." I understood, and maybe I'm making a mistake here, but I thought that very question went quickly to the Superior Court of Quebec, and the Superior Court of Quebec said, "You, the judge, can raise this issue on your own." Is that right?
From what I understand, the Quebec government, by the AG, they tried to go in front of the Superior Court and actually stop that judge from rendering judgment. This is an extraordinary interim measure called the brief of prohibition that you can go in front of the Superior Court to stop something from happening. They tried it didn't pass. So that led the judge to actually render his decision. And now, as you said, it will follow through the appeal process.
Yeah, because Simon Jolet Barrette came out and said, we're going to contest this all the way. And that's an as expected. But going back to now, this group that I had never heard of, Droit Collectif Québec, now going the ethics route and saying this judge actually violated his ethical duty as a judge. I mean, that's huge, isn't it?
It's a huge accusation. It's very serious. And it should be, and it is the exception to go with the ethics route. Because normally when a judge is wrong, and a judge has a right to be wrong, the normal process is to go in appeal. It's not to go through the Judicial Council and make a complaint in ethics. In order for them to succeed on this route, they will need to demonstrate that the judge essentially became a party of the proceeding, putting its own interests above those of the party and above those of the system. So I have not read the complaint, of course, but what was summarized in the paper yesterday was around those lines. And this is not the normal route. Normally, when you disagree with a judgment, you go in appeal.
Isn't this a dangerous path? And we're seeing, how politics has got intertwined in the judicial system in the United States, especially surrounding Donald Trump, but also Joe Biden's son, et cetera, et cetera, et cetera. But now, for me, this is something new. As an attorney myself, seeing now a group that basically is on the political side of things. This is not a group that involves itself in legal questions. They are for Bill 96, and it's their total right to be for Bill 96. But now using the ethics complaint route to try to, quote unquote, and these are my words, try to silence a judge that's raising a valid judicial question. Aren't we entering a very slippery slope here?
I don't know about that specific case. I'm not with a complaint, but
of course,
those type of complaints always have existed, and there is a expedited way at the Judicial Council so that they can see the complaint is serious or not. And I know that they received a lot of complaints per year, and most of them are dismissed very quickly.
Mm-hmm.
So I don't know what was their goal. I don't know if it's serious or not, but I agree with you that this is not something that we see often.
All right, Guillaume. I really appreciate your time this morning to help us make sense of this situation. We'll be following it very closely. Have a great weekend.
Thank you.
Guillaume Pelegrin, administrative law expert at Fasken, where he is a partner. I just want to say about this, when I was minister, I had some groups and individuals file ethics complaints at the Quebec Bar Association, saying that my political decisions violated my oath as an attorney, as a member of the bar. And the bar was very, very quick in dismissing all these complaints. But it's always like a tool that is used by people to disagree with you to try to say, well, you're ethically not supposed to make these decisions, and usually the Quebec bar in my case was very, very swift in dismissing. So we'll see what the Judicial Council is doing here, but the judge seemingly is within his rights. We'll see if the courts give him the go ahead and the green light on his decision. But as Guillaume Pelegrin said, a judge is allowed to be wrong, and that's what an appeal process is for. And this will probably get to the Supreme Court of Canada anyway, so we'll see. But to then go down the ethics route, that is very, very preoccupying, and I think we're trying to politicize something that should stay in the courts.